Hello, and welcome to the Washington Monthly. I'm your host, Ann Kim.
And I'm your co-host, Garrett Epps.
In this episode, Garrett and I dissect Trump's assault on big law. We'll discuss all the ways in which Donald Trump's attacks on big law firms are unconstitutional and why they should be trying harder to fight back. Hey, Garrett, It's great to see you again.
It's great to be here.
So, Garrett, let's start with some brief context to remind listeners of where we are. In the early days of his administration, Trump signed a series of executive orders targeting specific law firms, beginning with Seattle-based law firm Perkins Coie. These executive orders denied these firms access to federal buildings, stripped lawyers of security clearances, ordered reviews of federal contracts. Can you give us a quick reminder of who these firms are and why he chose to target them in this way?
Well, these are the mega firms, or among the mega firms in America: Skadden, Wilkie, Milbank, Kirkland and Ellis, Latham and Watkins. These names, grab attention in Washington, D.C. They are major players in litigation against the federal government in all kinds of lawsuits. They have huge presences in front of the Supreme Court. By targeting them, by issuing an order that they could not function fully, the president is going after the capability of the organized legal profession to stand in his way.
Mm-hmm. So basically what he's done with these executive orders by cutting off access to government is cutting off the lifeblood of what enables these firms to get revenue to begin with. And so as powerful and as big as these firms are, they're rendered helpless in a sense by what the president is doing with his EOs.
Well, they're vulnerable in two ways. And one is that they are now barred. Their personnel, and everyone in their personnel, down to the messenger, is now apparently barred from federal property, which means that when you go to court to represent your client in federal court, the lawyer can't go in. The other thing is that they deal a lot with regulatory bodies. They deal a lot with Congress. And this requires access to federal property. So their ability to represent their clients, their private clients, is compromised. Secondly, the administration says that the government is going to find out every organization or person who has a contract with these firms, that is, their clients, and then consider not doing business with them either. A blacklist of their clients. So as you can imagine, these orders will have an effect. They'll have an immediate effect. They are very much aimed at it's been described as an existential threat to these firms. It's certainly a severe one and intended to cripple them.
These firms that have been under pressure from Trump are reacting in different ways. So on the one hand, you have these firms that are announcing so-called deals with Trump. Paul Weiss, for instance, Skadden, in fact, was one of these firms. And I think they're promising at this point, nearly $1 billion worth of free legal help to Trump.
Yes, it's 100 million, 125 million a pop from the firms. And, it's represented as a commitment to pro bono. But pro bono we associate with, reaching down to represent the individual religious freedom claimant, or the person whose gun rights are being violated, or the woman who is beaten up in a congressional town hall in Idaho. Pro bono apparently has a very elastic definition. And one of the things that has occurred that is very striking, and I think will affect us going forward, is that Trump has begun to say, well, they promised to represent me. They promised to represent my administration. They've promised to engage in trade negotiations on behalf of the Trump administration, or various things like that. And I think it would not be surprising to see lawyers, associates, hapless associates from these big firms in 2026 drafted to present challenges to election results that displease the White House, or various cases like that, or even representing criminal defendants who are singled out by Trump, or representing Trump
Wow.
in terms of investigations, because the wording is very loose. A, B, the agreements aren't really binding, and that point is made very well in the legal ethics scholars' amicus briefs. These aren't really deals. These are
Right.
people saying, here's some money, Mr. Trump, please don't hit us again. We kind of know that when you say that to Trump, the first thing he's going to do is hit you again. You can't buy off the bully. You can't pay off the bully. The bully will always come back for more, and that's already begun.
All right, so you've got these firms that have capitulated, but on the other hand, you do have these firms that have chosen to fight. And that includes Jenner and Block, that includes Wilmer Hale. And so that's what brings us to the heart of this discussion substantively, which is that lawsuit filed on behalf of Wilmer Hale. And there are a lot of remarkable things about this lawsuit, but one of the most remarkable aspects might be the lawyer who's representing Wilmer Hale.
Yeah, that definitely got attention when the name of their counsel was announced, because his name is Paul Clement, and that name carries a lot of weight in Washington law and in the Supreme Court in particular.
And why
Um,
is that?
Paul, well, Paul Clement, I doubt anyone would disagree with me that Paul Clement is the greatest uh, appellate lawyer and Supreme Court advocate of his generation. It's simply not possible to overstate the degree to which this man has devoted himself to Supreme Court litigation very successfully. And as a result, I've covered arguments where Clement was presenting one side or the other, and it's what's striking is not simply how good he is, but how much the justices like to hear from him. Justices like lawyers independent of their causes. They like them if they know that they will tell the truth, if they know they will answer questions, if they know they will present the facts in a way that the judges can understand, if their arguments are clear. Um, and Clement manages to do this in a way that is completely um, inoffensive, that he is ingratiating without being smarmy. He just has this air. I've heard someone compare him to Mickey Mouse, in a positive way. That is, how Mickey Mouse is the host at Disney World. It's like, welcome, uh, Mr. Chief Justice, may it please the court. I'm so glad you could come to my oral argument today, and please let me help you. He's very effective in that regard. But the second thing is that he is one of the most conservative lawyers practicing in front of the Supreme Court today. He has argued 200 cases in front of the court, both as Solicitor General and as private counsel, and they cover a large menu of conservative causes, from opposition to same-sex marriage to Second Amendment rights, and similar high profile conservative causes. He is trusted by conservatives. He's very much a product of the Federalist Society and conservative um, network, and that carries a measure in and of itself. And thirdly, his own story illustrates a commitment to the independence of lawyers. He was, when he left the government, he went to a very uh, high profile, very lucrative partnership at King and Spalding, one of the mega firms. And at a certain point, not long afterwards, he withdrew because King and Spalding had decided not to take on certain conservative clients, particularly Second Amendment cases. He withdrew and moved to another firm that is a kind of boutique conservative firm. Obviously, we don't know the figures, but obviously could pay him significantly less than King and Spalding. But he did it because, and he said this at the time, lawyers, should be free to represent the causes that they think need representation. And he wasn't willing to stay at a place where his freedom to represent his clients was compromised. So he's a kind of living rebuke to the Trump administration in their attempt to annex these mega law firms and hobble them in making their decisions of whom to represent.
Yeah, that theme of independence, that lawyerly independence, really comes through very strongly in the complaint he drafted on behalf of Wilmer Hale. And so I think we should just go ahead and walk through that complaint. It's this 55-page, really elegantly written document, and it lists 11 separate constitutional violations, if I've got that right. I don't know that we're going to walk through every single one of them, but maybe we can walk through some of the specific provisions of the Constitution and Bill of Rights that are implicated in this suit that I think are really important for listeners to understand. And we're talking here about what he alleges are violations of the First Amendment, the Fifth Amendment, and the Sixth Amendment. He also alleges a violation of constitutional principles, including the separation of powers. So if we could start with the First Amendment violations, which he alleges, which actually may not be obvious to people who kind of maybe only think about the First Amendment in the context of free press. What is he arguing here about First
Well,
Amendment?
the very first sentence of his argument section in this complaint uh, references the doctrine of First Amendment retaliation. And what that means, it's a very powerful doctrine that if government takes some action against you on the basis of your free expression, because you criticize the mayor, the police come out and arrest you, something like that, that's a violation of the First Amendment, regardless of what the subject matter we're talking about is. And so he says the president himself in these executive orders says, I am retaliating against these firms for hiring people I don't like, or representing causes I don't like, or being affiliated with Hillary Clinton's campaign. And this is, if the retaliation doctrine has any meaning, it is clearly that. Now, also on the First Amendment area, he says that this violates the petition clause, which is a relatively less often cited part of the Constitution that of the First Amendment that protects the right of the people to petition government for redress of grievances. And he says, hiring a lawyer to represent you against the government is protected activity under the First Amendment. Acting as that lawyer, being retaliated against because you acted against that lawyer, violates the petition clause and violates freedom of association, and cites a number of very seminal cases from the civil rights era in which Southern states tried to make it illegal for the NAACP to represent more than one client, or to solicit clients, or to bring school segregation cases, and says, this is a violation of that freedom of people to associate together and bring their concerns before government through counsel of their choice. So that's the First Amendment part of it. There are four other parts, and I commend this complaint to any law students who are watching. If you want to learn how it's done, this is a really great example. Uh, we've got see, five more parts of the Constitution that he alleges it violates, and we can go through them quickly. There's the Fifth Amendment right to due process, the Sixth Amendment right to a fair trial. There's the Article 3 powers of courts, which the president is trying to exercise unilaterally. There is, and I love this one, there is the violation of the Bill of Attainder clause. That is that the government can't just proclaim you guilty of something and clap you in the calaboose or take your property. And that one is not litigated all that often, but it's a lot of fun. And then finally, it says the order is just unconstitutionally vague. No one knows what it means, which means no one can really comply with it, and the government can enforce it in any way it wants to. So, in general, sometimes lawyers are criticized for throwing too much spaghetti against the wall. But in this case, uh, Wilmer Hale had a lot of spaghetti to throw, and it's thrown pretty well.
Yeah, I want to ask you to talk a little bit about due process and equal protection because that's among the Fifth
Mm-hmm.
Amendment rights that they raise. And I think it seems to have implications for other contexts too, like what the president is doing against Harvard University, for instance, or against migrants that is deporting. We're hearing the phrase due process a lot. What does it mean in this context, and how does Clement's argument apply?
Well, the statement is made, and it's quite clearly true, that the law firms had no notice at all. No one from the White House reached out and said, "Hey, guys, we're thinking of issuing an order that will penalize you. Do you want to talk about it? Can we have a hearing or something where you can present your case?" Just like bingo, the president walks into the press room and scrawls his signature on a piece of paper and says, "Okay, that's it for your law firm. You're not doing business with the government anymore." So it says that's a violation. And then, secondly, as a due process matter, it deprives the firms of their property, and those are their contracts
Mm,
with their clients, because contracts are property. I mean, that's Hornbook law. So the due process clause, I think, is a backup claim. There's also an equal protection claim floating in this, because one of the aspects of these orders that is really quite pernicious is that the orders accuse the law firms of engaging in diversity, equity, and inclusion practices, which of course are not illegal,
right.
and says that they engage in discrimination and they have to agree not to do that anymore. So basically, the cynical view could say, um, that the government has put these firms on notice. They're hiring too many minorities, too many women. They got to get back to what they call merit based, which is referenced in the complaints, merit based hiring, which seems to mean more white men. And, we've read just recently that the president has ordered the EEOC, the Equal Employment Opportunity Commission, to begin investigations of these firms and investigate whether they're being racist by having DEI complaints. And a EEOC investigation is nothing to laugh about, whether you're an individual or a big firm. It will impose significant costs on and interference with their internal operations. So the equal protection clause is there. There's some seems to be some gender and racial animus being expressed in terms of challenges to their hiring practice. So that's
Mhm.
the Fifth Amendment due process claims. We've still got Bill of Attainder to go and vagueness. It's kind of, that's kind of. I mean, I shouldn't laugh. This is very serious, but it's also a kind of a fun tour through all the ways government can violate our rights.
I do want to ask about right to counsel, though, because the Constitution makes a big deal about having the right to counsel of your choice. And I'm wondering, just from a historical perspective, like why did the founders believe the right to counsel to be that important?
Well, the Clement complaint lays out some of this history, and there's also a very striking amicus brief by some professors of legal ethics that was recently filed in this case. And he begins with the fact that prior to the revolution, which we just celebrated, the 250th anniversary of the shot heard around the world. Prior to that, the British Crown had a practice of restricting what counsel people could hire and
Mm,
simply block or assigning them counsel, of the king's choice to proceed in an action against the king. The colonists objected very strongly to this, and one of the seminal moments of the growth of what we would call, a sort of revolutionary ideology was when John Adams, future president, uh, stepped forward to defend British soldiers who had massacred uh, anti-English demonstrators in the famous Boston Massacre. And he said, everyone has to have counsel. Everyone has to be effectively represented in front of a tribunal, regardless of what they're accused of, regardless of what they have done. And that from that, we derive a very broad set of rules that prohibits government from assigning people the lawyers that government chooses, or telling them they can't hire lawyers who are otherwise proper because they don't like the way those lawyers behave, or they don't want this client to be effectively represented. And thirdly, in that aspect, the complaint raises the fact that in some cases in the past, the Supreme Court has said freely chosen counsel that is free to make the arguments that seem valid, are an important adjunct to the Article 3 courts. That is, the court relies on the lawyers to bring the proper issues in front of the court. When you sue the government, you don't just go in and say to the judge, we think the government really screwed up here. Could you check it out for us? You're required to come in and say, here are the rights that are being violated. Here are the facts that show the violation. And if courts can't rely on lawyers, if lawyers are muzzled or inhibited or threatened because of arguments they raise, this is a violation of the inherent power of the courts to run themselves. And they cite a 2001 case, a very interesting case called Legal Services Corporation versus Velasquez, in which Congress passed a statute that said that no legal services lawyer could represent a client who was challenging welfare rules. In other words, you could represent a client who said, I'm entitled to welfare under the existing rules, but you couldn't also add a count that said, these state welfare rules violate federal law or the federal Constitution. That was just barred. And if that issue became an issue, the lawyer was required to withdraw from the representation, leaving the client in the lurch. An opinion by Justice Kennedy said, this is aggressive behavior toward the courts, not simply toward welfare recipients. So it is an interesting background doctrine. We'll see to what extent the courts want to move forward with it, but I think there's a lot to it.
So, given all of the spaghetti that's on the wall, given the laundry list of constitutional violations, if you're Trump's lawyers, what on earth do you argue? Is there any colorable claim at all that any of what they're doing is legal? Or more specifically, what do you expect Trump's lawyers to say in response to this?
Well, we've seen a variety of arguments on behalf of the administration from their lawyers, and I would expect you would see first the government lawyers to say that the court doesn't have jurisdiction over this. This is the internal operations of the executive branch, and for that reason, it's simply not a matter for the courts. The president can give instructions to his subordinates in any way that he wants. I don't necessarily think that argument is a winner, especially if it is, the Trump's lawyers have on occasion sort of added to this the idea that President Trump has a sweeping mandate from the American people, that he's, the supreme maker of deals, that he should be allowed to engage in this behavior because the people are behind him, which really is an improper argument for the government to make. But I would expect to see some reference in that. And then, I think there will be claims that the president is simply clamping down on unethical behavior, and has a right to do that, and could even say, is required to do that by the Take Care Clause, which leaves the issue of whether there is any law that the president can claim to be enforcing or executing. And important argument that is sort of non-constitutional or not entirely constitutional in the complaint is, the president. There's no statute that says the president may stigmatize law firms if he reaches such and such a conclusion. The president doesn't claim any statutory authority. He is not acting under any statutory authority. He doesn't cite any source of power. And we have a quote from the famous case of Youngstown Sheet and Tube versus Sawyer, which President Truman seized the steel mills and began to operate them as government entities to prevent a strike that was interrupting the shipment of steel to American armament factories during the Korean War. And the court stopped that. They said, the president can't create a statute that allows him to do it, and the president doesn't have any inherent power to do it, and Congress has not asked him to do it, and therefore he simply can't do it, and the courts must make that order. And that was one of the most famous constitutional confrontations in American history. And this is shaping up to be kind of a humdinger as well.
So, given none of the arguments you cited sound particularly convincing, so given that to be the case, what does the capitulation of so many big law firms tell you about the state of big law?
Well, I kind of this has a slightly emotional aspect for me. I've spent 30 years of my life training lawyers, many of the very brightest students I taught go into these firms and spend more or less time there, making a good deal of money and so forth. But the idea behind legal education, as I see it, the idea behind law in the United States is that there's Tocqueville said that in the US there's no nobility. It's not like England or pre-revolutionary France. There's no nobility, but the lawyers are the nobility. The lawyers have a trust that we as a society have implicitly given them to care for the law, to tell the truth to courts, to reach down as John Adams did and provide aid to the lowliest and the outcast and so forth. And in return for this, or an implicit return for this, these big law firms make enormous amounts of money. It's just staggering. Some of them have profits of $3, $4, $5 million per partner. And so their partners are taking home these extremely large payouts at the end of the year. And if they're going to roll over and play dead because a president doesn't like them and that might cost them some money, then what was this whole thing about? Why are we doing this? Why do we pretend that lawyers make a difference? And I have been shocked by the number of these firms and the number of practitioners, people I know and regard very highly, who are willing to say, well, the problem with this, it may violate principle, but it would cost us money. That's not okay. And a famous quote came to me while I was thinking about this, because each of these firms is given a choice. And there's a famous quote from the writer Robert Heinlein that says, there comes a time in the life of every human being when he or she must decide to risk life, fortune, and sacred honor on an outcome dubious. And those who fail this challenge are merely overgrown children and can never be anything else. Now, if you are asked to give up a quarter of your $1 million payout, half of your $1 million payout, well, as far as I'm concerned, boo-hoo, right? It's easy for me to say because I don't have any skin in that game. But if somebody's income falls at these stratospheric levels because they are defending the integrity of this profession that has been built up with such care and such assiduity over 250 years. I think that's all right. And if they say, well, we can't do it, we are for principle as long as it doesn't cost us money, you know, in the words of that old New Yorker cartoon, I say it's spinach and I say the hell with it.
And the other thing here is not just about law firms versus Trump. I feel that this is about the universities versus Trump and the nonprofits versus Trump. And there are broader implications, right, for these other institutions that are under attack. If WilmerHale wins, that's going to mean something for Harvard's lawsuit now against Trump, right?
Well, unquestionably, it means that in two ways. And the primary way is that every time one of these institutions stands up, uh, when after Columbia knuckled under, when Harvard basically sent the letter back to Trump and said, pound sand, we are a private university and we will not work for you and we are not afraid of you, do your worst. You could feel the atmosphere in this agglomeration of institutions, um, from law firms to companies to universities. You could feel the atmosphere change because someone stood up. And the same thing is true of this lawsuit. When you have, 7, 8 firms saying, well, what can we do? We just can't resist President Trump. He's just too powerful. And then you get Perkins Coie or WilmerHale or someone saying, that's spinach and to hell with it. We're going to fight and we will pay the price. That's inspiring. That is inspiring to smaller institutions, to ordinary people who have to decide how much they want to risk in order to oppose a president and an administration that is completely off the rails, lawless, and demanding sweeping authority over our schools, our universities, our museums, our law firms, our courts. Someone's got to stand up and say no. And when it happens, it changes the calculus. And I think this lawsuit is a setback for the administration. I think what Harvard did is a setback for the administration. I think we're going to see more of this. And if these institutions had rolled over, we would be in a much worse situation than we are right now.
Mm-hmm, mm-hmm. Now, at the end of the day, where do you see the Supreme Court ending up? Like, how confident are you that the Supreme Court will side with the law firms, the universities, and sooner or later the nonprofits that are going to be standing up to Trump in court?
Well, I my bookmaker will be sorry to hear that I don't bet on outcomes in the court anymore because it's just such a stochastic entity. But I think it is important to know that uh, these justices know, and some of them, Chief Justice John Roberts is a veteran big law attorney. He practiced for 8 years and made quite a bit of money
In fact,
before
we were at
going
the same
onto the
law firm.
bench. Is that right?
Yeah,
Did
yeah, we were both veteran. Well, I mean, he's obviously a much more distinguished alum, but he was Hogan and Hartson at the time,
well,
and now Hogan levels.
well, distinguished is in the eye of the beholder, and I'd rather be represented by you. But um, he does realize what being a private lawyer is, and he did take on some cases that were, he wasn't a cause lawyer, but he did take on some cases that were important to the conservative movement and opposed the federal government, like a case involving a government structure that was being set up in Hawaii to deal with the claims of Hawaiian natives that he successfully argued was unconstitutional and generated a certain amount of hostility. I think he'll understand that. I think we are seeing some disposition on the part of this court to try to split the difference, to try to remain lawful while not maneuvering itself, directly onto the railroad tracks. So, is there some way you could say, well, this part of the order is um, legal and this part is not? That is a tough assignment, even for a Supreme Court clerk, because as the complaint states, the president states his retaliatory, punitive motive in the text of the Constitution. Of the order, where he says, for example, Wilmer Hale welcomed Robert Mueller back to the firm after he weaponized the courts in the Russia hoax. All of this kind of Trumpian word salad. How can you approve anything that is based on that? But the other thing, Ann, is I think that the court is just as affected by the valence in the country as all the rest of us. And that to the extent that places like Harvard, four of the justices attended Harvard Law School, the places like Harvard or Wilmer Hale or any other big institution stands up and says, we'll pay the price. We will risk our life, our fortune, and our sacred honor, because what you are doing is wrong, it is lawless. Then I think the justices may be less inclined to hide behind procedural niceties and just say, you can't do this. And the fact that the president is picking on lawyers, because remember, all 9 of these justices are lawyers. That in itself sets the stage for the court to rule against him in whole or part.
Well, I hope that you are correct on that score. Thank you, Garrett, for this walkthrough, and fingers crossed.
Yes, indeed. And I will see you soon from my outpost in Oregon. Thanks for the opportunity to hold forth.
That's it for this week from the Washington Monthly. I'm Ann Kim, and on behalf of my co-host, Garrett Epps, thank you for listening. If you like what you heard, don't forget to subscribe to our channel or wherever you get your podcasts. Have a wonderful week.